Today's webinar is brought to you by the Law Society Pro Bono Services, LSPBS for short, and the Commissioner for Charities, or COC for short. So we live in interesting times. This is very challenging for us, and charity operations are being impacted by recent pandemic and new COVID-19 temporary laws. So we're going to try and use this session to give everyone an opportunity to understand some of the strategic issues, operational issues that could be of relevance to you. Please note that any discussion and any material that we provide in this seminar is not intended as a substitute for legal advice. Now, with that, I'm very delighted to introduce to you our panel this evening. And joining us today is Dr. Ang Hak Seng and Senior Counsel Gregory Vijayendran. Dr. Ang is the Deputy Secretary of MCCY, leading the ministry's efforts in Singapore Cares, the national movement to foster a more caring, compassionate, and inclusive society. He is currently appointed as the Commissioner of Charities. Presently serves as the Chairman of the Law Society Pro Bono Services. He is also the President of the Law Society of Singapore. He was appointed Senior Counsel in 2019, and he is a recognized expert in banking and insolvency, as well as charities governance. Dr. Ang, Dr. Greg, thank you both for joining us today. And before we start the webinar, we would like to invite Dr. Ang to say a few words. Dr. Ang?
Thank you, Jeffrey. Before I start my sharings, I must thank the Law Society Pro Bono Services led by my brother Gary, for doing this course on legal matters free of charge pro bono for all the charities. On behalf of the charities, I thank Law Society, I thank Law Society Pro Bono Services, and I thank the whole team here. Thank you very much. My brothers and sisters, thank you for spending this Wednesday afternoon on this online course on legal matters that affect us as a result of COVID-19. It has been now almost 6 weeks since we have a lockdown, and over the last 6 weeks, I have been in close contact with many of you. You have shared with me challenges as a result of our safe distancing measures, and I have been listening. I will attempt to group many of your feedback to me into 3 buckets. The first bucket is what I call the financial buckets. The second bucket is the administrative buckets, and the third bucket is the legal buckets, or the legal matters. The financial buckets, well, the main challenge you share with me is money not enough. This is partly because the way, as a result of our safety measures, you are unable or you have difficulties to raise funds as what you have traditionally do in the past, such as fundraising activities, or even going on the streets to house collection. But my brothers and sisters, to help you to overcome these fundraising issues, on 18th of April, in partnership with SUSS, I have conducted an online course on online fundraising. This is the way to ensure that you can continue to do fundraising even at the safety of your house. And online fundraising, as many of you all know, is the future. As the statistics have shown that the online fundraising is already on the increase before COVID-19. But also related to money not enough, you have also shared with me that you find it difficult to make ends meet. So last week, I conducted a course together with RSM, our local accounting firm, to share with you on the concepts of financial resilience. And in this course, I've shared with you how to keep your costs low and keep your revenue high. Productivity is important, and I've introduced also the concepts of economy of scopes, i.e. do what you do best, outsource the rest, and economy of scale, and that is to make sure that you have collaborations. Collaboration is important because collaborations give you the opportunity of win-win, lowering costs, and yet achieve a greater outcome. The second buckets of issue that you shared with me have to do with administration. There are administration issues that you are facing. During this crisis, you still need to comply with the charity regulations, the charity law, and one of it is to submit your annual report. I understand that sometimes it's not easy to pull up your annual report in these difficult times. And many of you have also shared with me that the auditor in the past will just go down to your place to inspect the books. And now they may have to inspect the books online, and that may take time. And because of all these reasons, I have extended the deadline for submissions of annual reports by 3 months to 31st of October. Recently, the government have also passed the COVID-19 temporary measures, whereby allowing you to conduct electronic AGM. Many of you all know that under the law, you need to conduct AGMs, but now with safe distancing, it's very difficult. So with this AGM, it enables you to conduct your meetings easily. However, there are rules that you need to follow. So in order to help you to understand the rules of electronic AGM, only last week, I partnered with the Chartered Secretary Institute of Singapore to organize an online course on how to conduct e-AGM. I'm very happy that the turnout was very good. In fact, we have 200 charities participating in these online courses. The third bucket that you are facing is legal matters. And I'm very happy that today, together with us, are eminent lawyers that you can consult so as to clarify what are your legal issues that create some uncertainty for you. There are 3 issues in the legal buckets that you have shared with me. The first one is regarding to liabilities. Many of y'all have shared with me that you are involved in contractual liability and contractual agreement, and that the COVID-19 measures have affected some of your contracts. Be it a performance contracts, be it a development contracts, be it a employment contracts. As you all have known that the governments have actually laid out a lot of help schemes, but the government have also laid out what we call legal relief in contractual issues. You have shared that you have some uncertainty in this area, and I think this is a good opportunity for you to ask our eminent lawyer if you are faced with some of these contractual matters. The third areas of legal matters have to do with alliances. I have been encouraging you all to proceed to form partnerships, collaboration between charities, so that you can achieve the outcome of 1 + 1 = 100. There are many forms of collaborations, and I call this relationship. The first level of relationships is a friend relationship, a friendly relationship, like two friends coming together to help our beneficiaries. Many of these relationships are informal, but it does have some legal obligations, even though it's informal. And this is a good time for you to understand what is your legal obligations if you come together informally to help our beneficiaries. The other form of relationship is from a friend relationship to a boyfriend-girlfriend relationship. And in these relationships, you start to formalize your partnership with fellow charities. A good example is MOU, signing MOU with fellow charities so that together we can serve our beneficiary better. But that will also means that you are upping your liabilities or obligations in a formal way. While it's not total obligations, but indeed definitely it will be partial obligations because of the MOU. But if you decided to deepen your relationship even further, from a boyfriend-girlfriend relationship to what I call husband and wife relationship, then it's no longer about partial obligations. It's about joint obligations and joint liabilities. An example of a husband and wife relationships is merger and acquisition. I always say that in charities, we must always look for opportunities to synergize. And you may adopt either one of these relationships, but they have legal liability and legal obligations, which I think you should take note of. And if you don't know what are they, I think again it's a good time to ask our learned lawyer. My brothers and sisters, I know this is a difficult time, but I like to see these difficult times not only as a crisis, but I like to see these difficult times also as an opportunity, as an impetus for us to improve. And this is where I want to touch on the last matter, and that is in the area of technology. Many of y'all have used technology because now you cannot outreach, you cannot have face-to-face encounter or face-to-face interactions with the beneficiaries or volunteers. So you make use of technology. But technology also has its legal matters that you should know. Recently, I received an email from one of the charities. And inside the email is a NRIC of a person. You know that actually the charity has infringes the PDPA Act, because you cannot share people NRIC with another person without consent. And now with us pushing for more collaboration, for example, collaboration between volunteers of different charities, you cannot simply just go and share the details of the volunteers from one charity to the other. Because if you do so without consent, you will infringe the Data Protection Act again. But there are ways to overcome it. And this is where I would like you to seek advice from our legal lawyers, our legal friends. The other legal matters that you must always be on the lookout for is our Computer Misuse Act. I understand that many of you are very prudent, so you share technology, you share computers. But I also came to know that sometimes for convenience, you share passwords. The danger is this: without adequate computer protections, such as you start to share passwords, and when somebody is able to illegally access the system as a result of the sharing of passwords, you are also liable. You may not be the perpetrator of the offense, but who says so? You cannot be the accomplice of the offense under the Computer Misuse Act. So again, these are issues that you need to know, that using technologies, you need to know the legal matters that affect technologies. And if you are not sure on it, please again ask our lawyers today. So my brothers and sisters, once again, thank you for spending this valuable afternoon on attending this course on legal matters affecting us during crisis. But as I said earlier, you will see this as an opportunity, and you see this as the way to improve your capabilities, then we will become stronger after the crisis. And this is what Singapore Care is all about. SG Care is about us able to bounce back stronger, able to ensure that we leave no one behind, regardless of good or bad time. So my brothers and sisters, finally, while you're doing good, please do take care of yourself, take care of the volunteers, take care of the beneficiaries, take care of the families. This is because only when we take care of each other will we able to bounce back stronger and better. Stay safe, stay healthy. Thank you, and you have a good afternoon.
Thank you, Dr. Ang, for that very inspirational speech. Thank you for setting out very clearly for us some of the things that we need to tackle as part of this session. So perhaps what we can then do now is actually turn to Greg, and if I could go to the next slide. And specifically, Greg, maybe just to go from big to small, the focus is to really just start at the strategic level to set the scene for charities and give us a sense of strategically what charities can do during this period to support themselves, their staff, and their beneficiaries to help take care of each other, as Dr. Ang has said. Over to you, Greg.
Thank you very much, Jeffrey, for moderating this session. Thank you very much, Dr. Ang, Commissioner of Charities, for those inspiring words and for giving LawSoc Pro Bono Services the privilege of serving you, even as we serve the charity sector. I will respond to what you'd asked me, Jeffrey, by first, I think, sketching out, the sort of overarching picture before delving into an overview of the COVID-19 legislation. I think many of us obviously came for this part, and we want to, take away some practical tips and apply them to our own charities. And we would have obviously differing impact and multifarious aspects that we want to consider the impact of this pandemic. I think it's important to note that it's an evolving situation. It's like nothing we've ever faced before. SARS obviously is eclipsed by a mile, but I think what we need to bear in mind are the wise words of Commissioner of Charities, Dr. Ang, in terms of the resilience, which the hope is that every single one of you that came for this seminar, and even those who did not, can embrace, even in this hour, it can present that valuable opportunity and impetus that Dr. Ang spoke about so eloquently and passionately to us as an elder brother would, for us to try and take to heart some of the lessons that could be applied in this setting so that, we can rebound back with resilience. I think from the point of view of the Law Society Pro Bono Services, we are keenly aware of the impact that charities have experienced because many of you, are friends at a personal level. Some of you are colleagues that we work with, and some of you have approached us for help, even through the services of LawSoc Pro Bono Services. And our aim is to try and see what we can do to reduce I would say, the consequence of this COVID-19 impact, so that there won't be tertiary casualties in the charity sector. I say tertiary because we know who the primary casualties are, those who are afflicted and affected by the COVID-19 pandemic. We know who the secondary casualties are, the economy. But we know that when the economy is hit, the donor dollars hit, and that's where there is a real risk of tertiary casualties among the donors. And our hope is that even through some of the things that we will share today, we can see how to build into that resilience. I will use that as a launch pad now to go into an overview of the COVID-19 legislation. To put the COVID-19 legislation, I think, into proper perspective, we have to give credit where credit is due, because the COVID-19 Temporary Measures Act 2020 is, in my view, forward-looking, cutting edge. It's something that involved a lot of thought, but it moved at the speed of light in Parliament, gave us a statutory force majeure and a national workout. And so what does this do at a practical level, and how does this impact charities? This legislation is in force for a 6-month time frame, commencing on 20th of April 2020, which may be extended for up to 1 year by Ministry of Law. So effectively, that's a statutory option to extend. I made the point about this being a sort of statutory force majeure, and it applies to a certain class, or rather certain classes of contracts that are entered into before 25th March 2020, and that relate to contractual obligations to be performed on or after 1st February this year, that we would need to ascertain are materially affected by COVID-19. So the laser focus is on what I would call COVID-19 impacted contractual performance. I made the point about different categories of contracts, and there are 4. First, leases and licenses of non-residential property. Secondly, event and tourism related contracts. Thirdly, hire purchase and conditional sales agreements. And then last, construction contracts and supply contracts. All of this would have some kind of relevance to the many charities here. So I'm just going to single out a specific example or two for consideration. And so if we look at it from the point of view of rentals, what does this act do, this COVID-19 Temporary Measures Act? The first thing you need to consider is whether or not you qualify for relief. And for that, you need to ascertain whether you have a lease or license for non-residential property, and you entered into that lease or license before 25th March this year. And thirdly, you're unable to pay rent or the charges from 1st February this year or later, and it can be attributable to COVID-19. And of course, by logical exclusion based on what I said, it's clear with a moment's thought that the Act does not apply if you have, for instance, a residential lease. And that's true even if the residential lease is used for business purposes, or if you have an inability to pay rent for reasons that are unrelated to COVID-19, so the nexus is broken. And thirdly, if you have a situation of unpaid rent before the window period of 1st February 2020, or the lease is terminated before 20th of April 2020, when the legislation came into force. What does the relief do? Effectively, your landlord cannot terminate your lease or evict you on the basis that you have not paid rent, nor can the landlord start or continue court or insolvency proceedings against you. And so that gives you breathing space to negotiate with your landlord for a plan to overcome the impact of COVID-19 on the performance of your contract. Now, it's important to note that this act effectively provides that moratorium that I mentioned earlier, or a suspension of the performance of your obligation, and effectively puts the brake on enforcement of rights or the application to court for remedies, by the landlord. But it does not change the fundamental of the obligation itself in terms of the actual validity of the obligation. So what does that mean? For instance, it doesn't mean that your rental obligations are extinguished. It doesn't mean that you don't have to pay anything at any point in time. It just gives you this breathing space. So rent and late payment fees, if applicable, continue to accrue. Rent is not waived. I mean, that could be part of the bargaining position that you could, sort of raise with the landlord. And rent that has already been paid can't be clawed back. If you terminate your lease, you will still be liable for charges and other penalties under your lease agreement, if applicable. And unpaid rent will also become payable. So I will just use that as an illustration. Another good illustration might be in the context of supply. When one deals with supply of goods as well. And so when you're dealing with supply contracts, same principle, it's essentially contracts that are entered into before 25th March this year. You're unable to perform, obligations, for example, to meet delivery deadlines and so on. And so in a way, that is a point that could operate in reverse, because you may not be the supplier, but you may have your supplier invoking this act. And so then the supplier will then rely on this act as a defense to a claim for breach of contract damages or liquidated damages for the inability to supply goods or materials due to COVID-19. And so this could operate not so much as a sword that you could use, like the example of the landlord-tenant, but it's actually more or rather, it cannot operate like a shield that you can use in the context of landlord and tenant. But in a sense, it sort of blunts your sword. So it's a shield that can be relied upon by the supplier against any claims that you may want to mount for breach of contract. So that's in a sort of snapshot some of what you can expect to experience under this legislation. There is a framework in which you have notification of relief served, and if there is a dispute, it goes before a panel of assessors. But I won't get into those aspects of remedies and so on until maybe a later stage of this webinar.
Thank you, Greg. And maybe just to get down a little bit into a bit of detail, it's correct, isn't it, that the organizations actually need to apply and file a notification for relief. And then in this form, they'll actually need to set out a proposal for what might be the alternative form of arrangements in reaction to COVID-19. And in particular, also demonstrate, or at least be able to demonstrate and justify the request for relief or for suspension of rights or the revised arrangements. Would you be able to confirm and sort of elaborate about that?
Yes, certainly, Jeffrey. So yes, it's triggered by way of that notification for relief that is served on the counterparty or counterparties to the contract. And there is a requisite form that's something that you can download from the MinLaw website. And essentially the relief applies after the notification is served. And then it triggers this process where the other party has an option of whether to agree or not agree. And if they agree, then of course it's consensual. But if they don't agree that the relief applies, for example, if they challenge the proposition that the inability to perform the obligations is due to COVID-19, and to be frank, we all know that there will be the genuine cases, and there will be the cases that are, disingenuous, and sometimes, due to non-COVID-19 related factors, and so there may be a challenge. And but of course, in the interim, there could well be some attempts to try and reach a compromise. But where you reach a deadlock, there's a disagreement. Then what will happen is either party could apply for an assessor from the Ministry of Law to make a determination. And so there will be an assessment. It's non-appealable. The determination is what I would call quick justice, and something that's done with a very, time-efficient, cost-effective manner, with a view to be fair to both parties. And so therein lies, I think, some of the ways in which it could play out. And you're right that I think there could be a variety of ways in which this could play out, including, for instance, in the context of leases. You might have a situation where possible outcomes could include partial payment of rent, or perhaps the rental set off against a security deposit, or the landlord may be allowed to terminate the lease if other tenants are available to take their place, or you could have some other creative solution. And so that determination is available to the assessor, depending on a fact-specific analysis of the case.
Thank you, Greg. I think we have a question from the floor, and I think it's time to address it, because while we're on this topic, the question specifically is, do tenants still have to pay interest for deferred payments and unpaid rent? And if so, how would we determine the interest if the contract is silent on the rate? So I think maybe this speaks a bit to the fact that we're trying to arrive at a rewriting, or rather a restructuring of the contract, and that's something that Form 1 that we have to file sort of addresses. But could you elaborate about whether this is a process by which we can sort of come to an understanding, and if there's some recommendation that might be available to a person who's relying on this process to try and address an issue like this?
Yes, thank you very much, Jeffrey, for surfacing that question, I think, from our audience. So I'll answer the second question and then answer the first. The second question, I think, goes towards the issue of whether or not interest is something that's contractually stipulated, either for non-payment or for deferred payment. And so the starting point is really to examine the four corners of the agreement, the contract that you've entered into, to see whether or not there is a contractual stipulation. This is where you get the help from volunteer lawyers, or perhaps even from LawSoc pro bono services at our clinics. And now, when you ascertain that there is a contractual stipulation, obviously the amount is aggregating, and it's a question of, unfortunately, payback, but at a later stage, right? You won't get this honeymoon period forever. You might get it for the 6 months, or if Ministry of Law sees fit, might be 1 year, and so then you might feel the full effect at that point in time. But if it is silent, then it's a bit more of a gray area, because, for instance, if you sue for interest in a situation where it's not contractually stipulated, the court has the discretion whether to award it or not. And it would, of course, weigh the fact that if you are successful from the point of view of the creditor, the fact that you've been out of pocket for this money from the time that you were supposed to receive it, and then will make an appropriate interest award based on a percentage. There's an element of discretion there, and so in a sense it's not cast in stone. So on either footing, whether you're in the zone of contractual interest or discretionary interest, the good thing is you've got the breathing space, and you can go back to the landlord and say, look, can you at least waive this and give me some time to service the rental obligation itself? Now, if you're having separate conversations with the landlord on reducing the amount to pay, of course, that's the bigger picture issue. But if you're quite content to pay the rental by way of installments and so on, then maybe the interest is where the bargaining chip is, to try and get the landlord to at least share in some of the suffering that's taking place.
Thank you, Greg, for that very comprehensive response. So essentially, there are solutions that could be negotiated as part of the arrangements, and it would be important to make sure that you take into account, or offer within the form at least, a proposal that addresses everything within the contract. But Greg has mentioned that we have COC clinics that can be used, and there'll be volunteer lawyers who can assist you on this. So it's important to make use of those resources in order to take you through what could be proposed. I think next we would go into, well, we've talked a bit about the strategic considerations. So maybe what we can do now is go a little bit more to the next slide. And here we would like to talk a bit about operational considerations.
Sure.
And then, sorry, go ahead.
Thank you, Jeffrey. So perhaps what I could do is maybe to set this against the framework of strategy and perhaps in a nutshell cover it, because I think we have to look at it from an overarching perspective before we get to operations. And I would like to accentuate some of Commissioner of Charities points, which I think are very valuable for this audience. And so I would actually make a fourfold point on strategic considerations. First, you have to have a caution about existential issues. Secondly, you have to conduct an evaluation exercise of what is mission critical to the charity. Thirdly, you have to consider enhancements to the structure of your charity. And fourthly, you need to think about creating enterprising solutions. So, if you want to remember all of this, there is a C and an E in every one of them. So first up, in terms of caution about existential issues, and that means, you need to take a hard-nosed, objective, brutally realistic assessment and diagnosis of your charity in the present circumstances, because you can't even answer the question of where you're going to go to unless you know where you are. And that's analogous to mission and vision. Mission is what you do, vision is where you go. You need to know what you do and whether that's affected by COVID-19 before you go further. And so I won't go further because I know we'll talk a little bit later about that portion in relation to insolvency, potential deregistration, and so on. But you have to be mindful of the red flags for existential issues. The second point I made was conduct an evaluation exercise on mission critical functions. And for this, you need to know your core. I think we heard the wise words of our elder brother, Dr. Ang, earlier about do what you do best and outsource the rest. That's very true in times of sunshine, and it's true in rainy days. In fact, it's probably even more true then. But you need to be able to ascertain what are you doing that's distinctive. And if that means this is the time to introspect and to evaluate what is core to your identity as a charity and what is it that's really not relevant now and non-core and you should hive off, then you should make that hard-nosed decision. I say that not from a theoretical point of view. I mean, I've led a charity before, Club Rainbow, and I remember in our early days, we went into blood donation, but we evolved and we realized that, look, Red Cross is doing this, and Red Cross is doing this really well. Why do we need to go there? And so we made the decision to basically cut off that service. And you have to, as much as you are sentimentally attached to some of the causes that are in your charity, and I understand that. I mean, I've been there, we've all been there, but you need to make that hard-nosed decision of what is it that you provide that nobody else provides, that niche distinctive. The third point I made was consider enhancements to structure, and I think we've heard the wisdom of Commissioner of Charities on options like, how do we do strategic alliances, partnerships, M&A, and I'm happy to answer that if there are questions about this aspect. I think Dr. Ang had alluded to this already in terms of the MOUs. At the same time, MOUs are not a label. It's really substance over form. What are the obligations that you are undertaking in relation to that? But is this the time that you need to enhance your structure by combining with other charities so that you all play to strengths and then you can make a difference? And the fourth point was to create enterprising solutions, such as, for instance, can you think creatively? For instance, would you be able to start a social enterprise arm that could make masks? Say, for example, just use an illustration, and that helps to meet some of the needs there, but then that becomes an income stream that could flow back to a charity. So this is a time to also think creatively. So I'll move from that. I just wanted to give that quick response on the strategic considerations. I'll move from that into what you wanted me to answer, Jeffrey, which is operational considerations and staff or volunteers working from home. And of course, you are the expert, Jeffrey, on PDPA and cybersecurity. So I'm not going to go in where angels fear to tread and leave you to be the expert to speak to us. But I would say this, that very critically, with work from home, We need to think a lot about issues such as data privacy and cybersecurity, where we need to listen to the pearls of wisdom from Jeffrey, but we need to think about confidentiality as well. For example, I mean, if family members are all working from home now, and say you have a family member that is a social worker or a counselor, now, how do you respect that space? How do you ensure privacy? How do you ensure that, even among yourselves as a family members, you have that segregated area, you have that area that is sacrosanct and allows for confidentiality to be preserved even while a counseling session is taking place? So these are very pragmatic points, but these are very important points to observe, because the mere fact that, we have circuit breaker now and, we are working from home doesn't obviate the ethics propositions that we all need to live up to as professionals and even as staff, and so that respect for the confidentiality and how that looks like in a digital world, as well as how does that look like in terms of the way we readjust and realign our working environment. So practically, should there be a dedicated area, and whoever needs to use that, whichever family member needs to use that area for confidential counseling, or confidential work, could use that space. These are things that we need to be thinking about. And of course, the fact that staff or volunteers are working from home, of course, opens up the entire vista on the third valuable point that Commissioner of Charities spoke to us about, which is tech. The ability to be nimble with tech, how to adopt and adapt to tech, in terms of our own environment. So I'll stop there, because I know, enough time must also be given to you, Jeff, to share your wisdom with us.
Thank you, Greg. But I think you've done a very good job in laying out some of the key points. As a starting point, all organizations, I think we're aware that ultimately we take responsibility to protect the data of not just of the beneficiaries whose data that we handle, but our employees as well, and our donors. So these are all stakeholders who have entrusted their personal data to us, some of which is particularly sensitive. So if you think about a donor that provides financial information, bank account details, or in some other form of personal data, these could all be sensitive and could be abused if not properly handled. So the first thing to do really is something that should be done with or without a COVID circuit breaker type of arrangement, which is to look carefully at your organization and ask yourself if you have some fundamental things that you have put in place. The first thing to put in place and be very, very clear to have set up is a policy, a data protection policy that communicates clearly how your organization is going to be collecting, using, and disclosing personal data. This is going to start as the orientation statement to anyone who shares data with you, and that the data protection policy, the DPP, is something that should be published or made public available for inspection. And this is not a question of discretion, this is a matter of law. It's required under Section 11 and 12 of the PDPA. So there are organizations that have not taken that step. And it's no wonder, because if you're living day to day and you have a lot of operations, business as usual, you'll have a need to address 100 other things. But as Greg has mentioned, as we go into WFH arrangements, it will be very important to ensure that that piece is taken care of. The second foundational element that you need is to ensure that all your employees have appropriate guidance as to how to handle personal data, sensitive information. And here, it's not just a question of understanding what the organization needs to do. It's also an SOP. It's also procedures in place should something happen. SOPs as it relates to handling of data, taking good measures in terms of ensuring cyber hygiene. These are all elements which are fundamental and which regulators will expect to look at should there be an issue, touch wood. So in terms of getting these foundational pieces, I think the COVID situation does in fact actually accentuate the need for it. And if we move into a work from home arrangement, as Greg has mentioned, particular care will be needed for this particular mode of working. So for some of us who need to share devices with individuals in the household, we don't have a business dedicated device, appropriate safeguards must be put in place to ensure that effectively you're not inadvertently disclosing information or exposing information to people who should not have access to them, even though they may be family members, loved ones in the home. It's important to maintain the work and family personal space distinction. If you're going to be using remote conferencing technologies, please be aware that there are very important things that can be done to ensure that you put some basic safeguards. I believe there is, in fact, in the materials given to you, some basic online cyber hygiene tips to take into account. These are all elements which come with any operation that moves into remote working arrangements. And so that's particularly important. Now, you might all have seen recently that the PDPC has issued a consultation in relation to new changes under the law. You'll notice that one of the things that the PDPC has proposed is mandatory breach notification. Now, this is some time ahead of us, but if we're to live with a certain amount of work from home arrangements going forward, it's important to recognize that the time is now to make sure that you put in place appropriate data breach responses. What this means is just sitting down and asking yourself, well, have I taken care of what I need to take care of in terms of delegating responsibilities? Does everybody know what they need to do in the event that there's a data breach? This is both a legal and a practical matter. Essentially, you'll be needing to review your SOPs and make sure that they're implemented internally within the organization. And this could also mean getting in touch with each other and coordinating, delegating response, making sure everybody has time, has an action plan. The last piece to do is very important, is to look at the consent situation. A lot of our Data Protection Act still remains consent-centric. What that means is that you can use the data to do the work that you need to do, but to a degree, it's also important to be clear whether the data subject, the person identified by the data, whose data you're handling, has given consent or understands that you're going to be using the data for the purposes that you need to do. So again, these are all things that need to be taken care of. Part of it is in legal documentation, which is to say that in your relationships with your donors, with your beneficiaries, and even with your employees, there are appropriate policies and consent statements in place. But it is also practically understanding what the limits of that consent is and making sure there's an internal discipline within the organization to adhere to those things and to make sure that the culture of data protection is actually carried through within the organization. Now, in terms of cybersecurity, Dr. Ang has mentioned Computer Misuse Act, and that's not a laughing matter. That's very important. People sometimes are inadvertently caught by the fact that they share passwords. They create situations where it is possible that a person might inadvertently or even purposefully misuse computer resources in a way that it is not intended. And if this is a matter that triggers a complaint or an issue by an individual, the consequences could be quite serious because Computer Misuse Act related matters are matters of criminal prosecution. In other words, they are not to do about claims between the parties, but they are matters which deal with the police. And so it's important to recognize that disciplines must be in place. Do not share passwords, do not share accounts if you can, and maintain strict and clear lines over when an individual should be accessing data or not. These are mappings and things that need to be done internally. And I would urge any attendee at this talk to think these things through carefully, because data now has reached a point where if something goes out on the internet or goes out inadvertently in an email, that data is there forever. It's practically difficult to remove. So these are things that we can't take lightly. So with that, I hope that's useful for you. Greg, perhaps in terms of what we had discussed earlier, I think Dr. Ang had also mentioned about one of the things about working remotely was to deal with the conduct of meetings online. And I was wondering if you could talk a little bit about that. That would be very helpful for the attendees.
Certainly, Jeffrey. I'll be happy to speak to that. I think we again have to put this aspect against the broader context, and the broader context is we are all trying to combat this pandemic and its effects on the ability to conduct physical meetings. I think the issue comes into sharp focus for the AGM. The AGM, as we know, the annual general meeting, is the forum in which members are updated about the charity's activities. The financial information of the past year is shared. The upcoming plans of the future are revealed. And of course, you have the all-important agenda, which does take place according to the terms of the charity's own constitution and, of course, the relevant legislation on the election of the incoming governing board members. There are nuances, obviously, for charities that start with the foundation of a company limited by guarantee, because ultimately it is a company, versus that related to a society, and the charity is then one that sort of is built on that foundational structure of a society. And then of course you have the third for completeness, which is the trust fund, but that's a bit more unusual. And so I think in practice you're really talking about societal AGMs and company AGMs, and there are valuable legislation that has been mandated in respect of this, which is something that all of us need to be aware of, according to whether or not we are a registered charity that was established as a company limited by guarantee or a registered charity established as a society. And the relevant legislation is the COVID-19 Temporary Measures Alternative Arrangements for Meetings for Charities, Cooperative Societies and Mutual Benefits Organizations Order 2020. That's for CLGs, or companies limited by guarantee. And the COVID-19 Temporary Measures Alternative Arrangements for Meetings for Registered Societies Order 2020. That's for registered charities that are established as societies. And so from the point of view of the considerations that you need to have in mind when it comes to an AGM, the first question you need to ask yourself is, must you even have this AGM? And for that, you need to check what the legislation says, what the governing instrument of your charity says. And if the answer is that you need to have it, then of course the question is, what must you transact in that setting? And then the next question which you will need to ask yourself is, can you conduct a physical AGM, or is that something that is unfeasible having regard to the current safe distancing measures and the way that we need to manage physical meetings in the light of the circuit breaker phase and the measures involved? And so that modality of the AGM needs to have careful and due consideration for safe distancing measures. If you consider as a charity trustee that you can have that physical meeting in accordance with existing law or the charity's governance instruments, and that you can do so without breaching either the letter or the spirit of the safe distancing measures, then you could have that physical AGM meeting. And when you do, then of course, for the purposes of that, and I know we're coming towards the end of the circuit breaker, but the current regime is still something that involves general exemptions and time-limited exemptions. And so for the purposes of having the AGM proper, you would then apply for a time-limited exemption to have a skeletal number of staff involved to help support it and ensure that you've got sufficient safe distancing measures. Now, the beauty of this legislation that I read out to us earlier is that it's not mandatory, it's permissive. And so where you can't have that physical AGM because you know that you cannot do so without flouting either the letter or the spirit of safe distancing measures, then the law gives you this option to have virtual AGMs. And so in that sense, it's permissive, and you could utilize it effectively to hold your AGM. In terms of what you would need to consider in having this, there is a valuable write-up available from the charities portal on guide on conduct of meetings by charities um, in the midst of COVID-19. And so you would need to read that, because that gives a lot of practical tips. But if I can just offer some wisdom here, I think the starting point is you could convene, hold, or conduct, whether wholly or in part, that meeting electronically. And that means, of course, through Zoom calls, through other ways of electronic media in order to transact an item. And what happens then is that the company, and my observations here are just going to be in the context of a company, but there are a parallel set of requirements for societies as well. The company may provide that a member or person may attend a meeting by observing and listening to proceedings of the meeting by electronic means, if there is access made available to both audio broadcast as well as to the electronic participation in that meeting itself. And so you have to avail yourself, avail the members of this option electronically, so that it's even-handed in that sense, quite apart from being legally permissible. And so then what happens is that the members would typically be able to raise matters before the meeting by sending them to the chairman of the meeting by post or by email. And then the legislation uses these operative words that for such matters, if substantial and relevant, and essentially that it is something that satisfies those two criteria, then they must be responded to during or before the meeting electronically. Now, a moment's reflection will show the wisdom of this requirement, because quite obviously, if it's a substantial and relevant matter, you want to have, I think, the clarifications from the charity itself shared with everyone, so that by the time you come to the meeting, everyone is put in a position of symmetry in terms of informational responses to that question. This is significant because of another curious feature of this legislation, where in terms of voting, unless your constitutional documents allow you to have electronic voting, then the way you would vote is by appointing the chairman of the meeting as the member's proxy. And so that means that you would essentially be voting by sending those proxy forms that indicate your decision and submitting them either by email or by post to the chairman. And you can see the link between this and why matters that are raised by members should ideally be dealt with before the meeting, so that everyone is in the know and can vote from a position of information, and so then sort of decide according to the information on the key questions relating to the same. And so another point to bear in mind about such meetings is that quorums may be formed by members personally or electronically present. A member is deemed to be present if the member has appointed the chairman of the meeting as the member's proxy to attend, speak, and vote at the meeting. And so that's how I think these points actually help you to conduct a legally valid AGM and to transact the business in that AGM in accordance, with the various provisions that exist right now in the Constitution. And so then you can actually discharge your duties, as it were, electronically. So those are some points that I would share, but I'm happy to get into even more nuance and detail depending on the questions, or depending on how you want to take it further, Jeffrey.
So I think it would be good to just clarify upfront also. We have two questions on this point. So very quickly, just to clarify that effectively these provisions under the legislation are permissive and allow you to do these virtual meetings if your constitution is silent and doesn't prohibit this arrangement. Would that be the correct understanding? If your
Absolutely, absolutely. So it's not mandatory, it's permissive. You can even do a hybrid of a physical come electronic. And so the legislation allows you that flexibility. But obviously, if it's prohibited, it's game over. You can't do it. So then you have to look at a deferment option, and it's comforting to know what Commissioner has told everyone here about even the extension of time for the submission, of their ARs. So in that sense, there is a Hobson's choice if your constitution says no. But if your constitution is silent, then this, essentially allows you the option of conducting it in lieu of or in tandem with.
Thank you, Greg. That's very helpful and clear. Perhaps we can go to the next topic, which is really about fundraising. And Greg, I think this is an issue that might come up when you have COVID-19 campaign fundraising issues. And maybe this is an opportunity for us to discuss any particular legal nuances in terms of collecting money in such situations. Could you help us with a little bit on this topic?
Yes, I think this is actually very, very, very pertinent because we see a lot of needs. I mean, we open up the newspapers, we watch social media, and our hearts bleed when we look at some of the causes around us, and some of us, who are charity trustees, may also feel that we need to do our part, to raise a kind of dedicated COVID-19 funds, or start a COVID-19 campaign fundraising to meet some of the needs that are out there at present. For instance, whether it is in terms of distribution of masks, meals, and so on for beneficiaries that we're serving, or other types of segregated or designated or even restricted purposes. Now, the biggest danger with this that you need to be very mindful of, and I couldn't underscore this point enough, that when you do this type of restricted or designated fundraising, you are immediately locking yourself into that specific purpose or to that restricted purpose. And that means that your donations can only be used for that restricted purpose and for no other. So that immediately raises two sub duties. One, the duty not to raise excess restricted funding, right? Because obviously we have to apply our minds and our parameters to how much fund is enough, right? It's not a bottomless pit. But then there's a second point which actually touches on something very serious, and that is you can only use the funds for that restricted purpose, and you cannot, as a corollary, use that funds for unrestricted purposes, because the moment you do, then it's breach of trust, and you're exposing yourself to risk in terms of breach of trust, and various sanctions that could be meted out by Commissioner of Charities, who may not be such a friendly elder brother then, in that type of setting, and as well as potentially regulatory infractions, quite apart from losing your credibility with your donors. I mean, there is some way to apply wisdom about this. Some people would have a catch-all when they actually raise funds, and make it very clear that should the funds raised not be used for this purpose, then there would be a discretion conferred upon the charity trustees to be able to use this for such alternative purposes, and that could be one way to do it. You need to have the right wording, work with volunteer lawyers, either within your team in the charity itself, or even from LawSoc pro bono services. So there's some ways to do it in a way that kind of stays to the straight and narrow. But I cannot underscore the point enough that you need to be very, very, very conscientious when you raise these restricted funds, and that you also have to have a reality check. How much can you reasonably raise? Both of these points are very, very critical. So that's a very important point. But I would also say that when you go further, then you need to be mindful of charities fundraising appeals for local and foreign charitable purposes regulations 2012, which stipulates, and it's hard-coded in the law, but it stipulates that you have a duty to donors to be accurate and not misleading. And I'm afraid even in the present environment, I've had to advise on one situation where the messaging, I think was suboptimal. And so in that sense, you have a duty to be accurate to your donors and the public. It's very easy to oversell, to be exaggerated, to embellish, and to overstate things. And sometimes, maybe you might do it because, you yourself are feeling for the cause, but your language and your appeal has to be honest and accurate and not misleading. There has to be integrity about it. And we know also, for those of us that are familiar with the Code of Charities governance, that there are twin principles of disclosure and transparency. So that's very important to bear in mind, even in terms of the messaging to the donors. Related to that, the information relating to donors have to be kept confidential. We've already heard from Jeffrey about this, and I would just reiterate that. Information relating to a donor should not be given to any other person without the consent of the donor. And obviously, when you solicit donations, you need to ensure proper accountability and prevent a loss or theft of donations. When it comes to the use of these donations, use them according to the donor intent. And so obviously, if it's restricted, it has to go in full alignment with that purpose. If the money was only earmarked for buying masks and meals, or having hygiene care packs and so on, it can only be used for that purpose. If not, you have to refund it back to the donor, and be responsible. And so, that purpose has to be communicated. We've already made that point. I would also finally make a plug for the point that Commissioner has raised about online fundraising. I think this is a golden opportunity. So this is not so much a prohibition, but a clarion call that charities should think seriously about online fundraising models, or what I would call crowdfunding from the virtual community, and to consider such options at this time. I think the happy experience that I've seen working with a few charities, and obviously I chair Laws of Pro Bono Services, is that we're starting to see attraction with this type of fundraising. So I would commend that to you, and just echo what Commissioner has said on that front as well.
Thank you, Greg, for that very comprehensive coverage of that topic. Perhaps we can talk a bit about other risks. If there was other areas that you think we should address before we go into other further topics on the head.
Yes, I think we touched on so many areas of risk so far. So I won't belabor the point, but let me just single out 2 points, one of which I've already covered before, which is confidentiality. I think we can be seriously loud when we work from home to overlook the fact that a lot of matters, for instance, if you're a case worker, a social worker, and so on, providing counseling, and even when it comes to some of the confidential aspects that you need to observe in the course of your work, to keep that, to really ring fence that, to have that sacrosanct. So what does that look like in terms of, the kind of virtual and the digital protections that are needed for confidential information? And what does that look like in terms of, the hard copies? You can't just leave them lying around so that family members can all look at them, right? If you happen to be caught on camera like this with a family member kind of coming into the picture and looking at confidential information, then you're just exposing yourself to risk, at an ethical front as well, in professionally. So I think we need to hark back to what Jeffrey said on that front. The second point I'd raise is that from a risk point of view, this can be a turning point in your charity. Commissioner has spoken about the impetus, but it could be a negative impetus if you are basically sleeping at the wheel. This is a time when you can seize the day. For instance, even with your volunteers, maybe it looks like you can't carry on some of the usual activities or the programs that you have, but how can you think about engaging your volunteers? So that, for instance, in as much as you're trying to keep the ship afloat and keep your staff meaningfully occupied, but how can you engage with volunteers? And so one of the best ways is actually training. Have some training. We saw the experience in Laws of Pro Bono Services that with the kind of primer trainings that we were giving, we saw record attendances, for our criminal legal aid scheme and so on. And so this is the golden moment when you can actually keep that link with the volunteers alive, by providing training in this downtime and using webinars like this, to share with your community. So that's one risk I wanted to touch on, that don't lose your volunteers at this time. You can actually engage with them.
Thank you so much, Greg. Perhaps we can also go on a little bit now to talk about meeting debts and liabilities, sustainability here, because what if a charity is unable to meet their financial obligations due to a decrease in funding and obligations? Could you take us a little bit about some of the options that we could sort of explore going forward?
Yes. Now, this is very sad, of course, because we all feel attached. I've been serving in the charity community almost from the point of graduation, being one of the founding members of, Children's Cancer Foundation, at that time known as WALK, and then later leading Club Rainbow, and then playing advisory roles in some other charities. And I've seen life cycles of charities. I've seen how some charities have had to make that painful decision also of closing shop. That's always very hard, But I also think we have to be, I go back to something I said at the beginning, we have to be very hard-nosed and objective and brutally realistic about the diagnostics. Some visions are only good for a finite point in time, and you have to evaluate, the continued raison d'etre of your charity. So if you evaluate diagnostically that it's not just a temporary liquidity problem you're suffering, or a temporary donor dip in terms of support, for which, of course, you may need to find other things like making appeals, getting your board members to write letters, sending personal appeals, and all that needs to be done. But if you come to the view objectively that you have a sustainability proposition at stake here, and that you're either going to be insolvent or imminently insolvent, and by that there are two types of insolvencies. You get the balance sheet insolvency, you get the what I would call the operational or commercial insolvency, where, and I know commercial, I'm using that not in a technical way, because I know we are all non-profit, so it's not really commercial. But what that means is where your liabilities overtop your assets for balance sheet, and then where, when it comes to operational, your income can no longer, sustain your expenses, or you're unable to pay your debts as and when they fall due. Now, if you are in the very happy position of having reserves, maybe this is the time to unlock your reserves. Of course, in a way that's consistent with what you have in terms of your reserves policy, and in a way that makes sense. I mean, extraordinary times call for extraordinary measures. So if you need to dip into your reserves and that's the right thing, do it. But if you come to the end of your tether, then the right thing to do, the responsible thing to do, is to call it a day. And again, I'm not going to take away the emotion from this. I know this is tough, but you have to make that, because you have a duty as charity trustees to be prudent and to be responsible. And part of that is acting in the best interest of the charity. So if you can no longer sustain, then you're in a very dangerous zone, which I would call the twilight zone. And that's the term we use even in insolvency settings, where you could be running the risk of wrongful trading. You're entering into contracts, but you're unable to service those contractual obligations going forward. So is the better solution to call it a day? And if so, then you may have to wind up or dissolve. And then, of course, related to that, there are deregistration processes, charity deregistration processes that you need to consider, which, of course, at the end of the day will entail a whole host of procedures, such as, submission of your final set of accounts that are up to date in terms of the date of winding up or dissolution, the final copy of the AR, the minutes of the general meeting in which the dissolution resolution was passed, and then proof of distribution of the remaining funds in the account. And so that means the receipts of where those funds went to. So I'm afraid, that's the final end game. But that may not be the only end game, because we go back to what Commissioner said about options that may involve moving from boyfriend, girlfriend, and perhaps maybe it starts with best friend, and then boyfriend, girlfriend, and then maybe sweethearts, and then finally husband and wife. And so maybe you need to consider that journey of amalgamation, where you can play to strengths and maybe then stay alive, through a different form. That does not come easy, because there are a number of considerations that go into amalgamation. Will you dilute your brand identity? What happens to your existing staff? Are there liabilities that you're going to entail? And so there's a whole host of considerations. Lawsort Pro Bono Services has a wonderful checklist as part of our resources that we'll be happy to share with you. with a variety of detailed considerations when you do an amalgamation, which could come in the form of mergers, or it could come in the form of other things. So you need to be, I think, very careful about that, because it's a hard-nosed diagnostic. Is this temporary illiquidity, or is this insolvency?
Thank you, Greg. I have some, I can see that there's some really interesting questions that are coming in right now. So I think maybe we need, we'll try and pick up the pace a little bit more. And maybe we'll talk next a bit about financial relief. And really just to, very briefly to cover what financial relief schemes are available to charities for now. If you could help us with the audience with this as well.
Sure. I touched a little bit on the options that are available in the legislation, which I spoke about at the start, COVID-19 Temporary Measures Act. And so in a way, that relief that you get, which is really moratorium, you don't change the validity of the obligation, but you only change the enforcement of the obligation. But that still gives you some relief. It takes away some pain. And I think that's important to note. It's a moratorium on enforcement of rights and pursuit of remedies. It's meant to temporarily alleviate some of the financial burden during the prescribed period, but it doesn't diminish the sanctity of the contract. But that's available to you. Related to that, and this is a point I wanted to share in connection with Jeffrey's question, you can have a rebate of property tax and a transfer of benefit in relation to property tax that are remitted. So the same act I referred to requires that landlords mandatorily pass on to tenants any property tax rebates granted by the Ministry of Finance in response to COVID-19. And I'll make 3 points on this passing on. Firstly, the benefit must be fully passed on. Secondly, the passing of the benefit must be unconditional. In other words, the landlord cannot use this rebate as a bargaining chip to renegotiate the lease terms in a way that may be more favorable to the landlord. That would be void. So it's got to be unconditional, not conditional. The third and final point is it could be paid as a lump sum or by installments or set off against payable rent. And that's very pragmatic, because many of us know that our rentals are a huge operating expense for our charities. So that's an important set of reliefs. There are a number of other measures that the government has also taken, and I think I won't go into the JSS and other things, but those are wonderful ways in which the government has tried to ameliorate some of the personnel costs on the part of organizations and so on. And so you need to read up on that and avail yourself of that. And I think in terms of the reliefs, the legislation that I mentioned by way of the rentals and of course the various other classes of contracts should be examined to see whether or not you tick the box in terms of some of this, and will be able to invoke some kind of temporary relief so that you can do some restructuring and negotiation with the landlords and or with the other contracting counterparties, hire purchase companies, conditional sale companies, suppliers, and so on.
Thank you, Greg, for that. You mentioned personnel costs, and I think that's probably the next topic we should address. Given this is a big piece of any operational costing in the P&L, can or should charities essentially reduce salaries or retrench employees during this period?
Yes, I think that's a nice segue, Jeffrey, into employment as well. So I think these are tough times for all of us, even for the for-profit sector. But the approach that we should consider seriously taking is to look at alternatives to retrenchment. Are there other alternatives that we can examine at this time that can help to weather the storm in terms of the options that may be available for our charities? And so what that may look like would be, and this is actually from the MOM website, but I'm going to contextualize it for the charity sector. One alternative, there are actually potentially 5 alternatives. First is training. You can take this opportunity of downtime to do training and skills upgrading of your employees. That's actually been one of the feedback that we're seeing even in areas like the legal profession and elsewhere, that this downtime can be intelligently used. And it's also one of the key strategies recommended by the tripartite partners. So, if there are ways in which you can tap into the Skills Future scheme or redeployment programs under the Adapt and Grow initiative and other government grants, this is the time to do so, so that you can actually help your staff to sharpen their saw. But one of the points to really think about strategically also, and I know this is HR, but you also still need to think strategically about HR, is what are the kinds of skill sets that will be important to your charity in a post-COVID environment? Because as part of the assessing of continuing relevance, what are the kinds of skill sets that you may need to have for the employees involved? Where are the gaps? Where are the deficits? And how can you position yourself? And so maybe these are ways in which you can be quite intentional and quite intelligent about the training of your staff. And essentially there could be subsidies that you would be able to tap into. So that's the first point. The second point is redeployment. If there are changes that you can make to redeploy or rotate employees within your company to areas where the job scope is enlarged or enriched or even enhanced, then maybe that's the natural thing to do. And you could combine that with the training piece that I mentioned earlier, so that they get the relevant training and are up to speed in terms of that area. And so, for example, if your beneficiary interface, if you're working with a particularly vulnerable population, the beneficiary interface needs to increase, then maybe some of the staff that are not doing the direct interfacing who needs to be redeployed into this area could be redeployed with the necessary training, and it adds a depth to even their own job scope. Of course, it's got to be done consensually, but it's better than taking the harder decision of retrenchment. The third point I'd make is, could you implement a shorter work week? Could you ask the employees to work only a few days a week for a short time? There are some, of course, limitations to this. It should not exceed 3 days in a week. And it should not last more than 3 months, according to MOM's own guidelines on it. But that could be one way where perhaps you could do a shorter work week, or perhaps you can do a hybrid of part work from office if your office is considered to be essential and urgent, and then the rest of it is WFH. And then fourthly is a temporary layoff. You could ask the employees to stop coming to work for a short period of time, but again here, this is not the option that you want to explore at first instance. It's something that's almost like a second last resort, where you would just do that layoff, but provided it doesn't exceed for 1 month in terms of time period. And there are some parameters like you can ask your employees to take up to 50% of their earned annual leave. You can you can actually pay at least 50% of their gross salary during days that they are temporarily laid off. Again, not the best. And again, it is a hard decision, but it's better than a full-blown retrenchment and axing from the job completely. The last and final point is cost-saving measures. And for this, if there is really a very poor state financially, and there's uncertain environmental conditions, so that you are indeed a tertiary casualty, and you're suffering from a very, very poor income, and this is likely to be in the long haul, then you may have to have a hard-nosed conversation, a very frank one with the staff, to maybe make an adjustment to wages so that you can reduce manpower costs. And that could be adjustments to annual wage increments, introducing a monthly variable component, and so on. Or perhaps, last resort, do a no-pay leave. So these are the 5 alternatives that could be considered: training, redeployment, implementing a shorter working week, temporary layoffs, and other cost-saving measures, including making some calibrated adjustment to wages.
Thank you, Greg. Thank you very much for that very informative session. Perhaps now we could also go into the Q&A section. And for this, I would also like to invite Dr. Ang back for an interaction with him. And we've gotten quite a few questions in here, some of which have been addressed earlier. So I'm going to really tackle and get to as many questions as we can. The first question queued up in terms of the things that have not been addressed is this a question. I'll just read it to be clear. may I know if the members need to see each other in an AGM when it's electronically run? So this is taking out the point that some platforms effectively only let you see a number of participants at any one time. And then sometimes the platforms only let you see the last person who spoke. So the question really is whether or not in an AGM, it's necessary for you to have visual contact with all the participants. I think this is fairly quick, but could I direct the question to Greg for this one?
Sure. Yes. And so the way the legislation is couched, the requirement is that the member or person may attend the meeting by observing and listening to the proceedings. And so there is no requirement of observing and listening to other persons as well. Of course, pragmatically, if you can do so through certain technology like Zoom, for example, like now I'm seeing Dr. Ang and I'm seeing Jeffrey, right? And that's wonderful, but some technology may not allow that. But what's significant to note as well is that from the point of view of even the recognition by the chairman, of the meeting, the chairman has to be able, I think, to observe you or to take note of your attendance. And so this is where I think it is important that it's actually something that's spelled out in the guide proper, where you want to try and maximize that participation by the members themselves, and there needs to be that acknowledgement by the chairman, of the presence of that particular member themselves, so that in a way it can count towards the participation in the meeting. So I think some pragmatic tips here are that ideally, and I don't want to over legislate, but I think ideally for these types of meetings, you should try and focus on what is essential and urgent. What are the bare bones that you need to transact in the virtual meeting? Because there are limitations. You're not going to get the real-time dynamic of a physical meeting. And hence, I think where you can, try and direct the questions ahead of the meeting, as I'd advocated earlier, so that you get clarity and everybody gets the transparency of that answer. And then when you go into the meeting, all right, you have already voted by either by proxy, giving it to the chairperson, or you are in a position of knowledge and there's actually very little debate that takes place in that context. Where it is not essential or urgent, if it can be postponed to a physical meeting, then go for that option, especially if you know that something is particularly contentious. So that would be my own counsel of prudence in this setting. But the short answer to the question is it's not necessary.
Thank you, Greg. The next question we had to do with actually excess donations or the monies that were received during fundraising. Specifically, if you raise too much funds or you raise funds and you want to be able to change the use of the use or the purposes for which these funds are applied, is it necessary to go back to the donors to get consent for the change of purposes and the change of use? Greg,
yes, sure. So the short answer to that question is a resounding yes. There is another avenue, I think, which involves your sector administrator giving approval for that change of purpose. So that's another binary option. But the problem is that you could get into all kinds of situations if you want to wait until that event and go back to the donors. If you decide to invoke that option, because supposing they are not minded to change that original purpose, or supposing, like in one example that I'm aware of historically, where the donor says, no, you keep the money. Well, then you're stuck, right? You can't carry out the purpose. You're stuck with the money. Then you're in a real legal conundrum. And then, of course, you take the risk that if you apply to COC, it really depends on the wisdom of Commissioner of Charities and the case that you make, and whether or not it's compelling enough to justify a variation, because bear in mind it's a variation of the original donor intent, which is why the wisdom is try and deal with it upfront. Try and have an alternative inbuilt when you make that appeal upfront, so that you either reserve a discretion to the charity trustees, or the charity trustees can't use that arbitrarily. You can't use it for anything under the sun. according to your whim. You're still limited by the constitution of your charity. But at least with that plan B, you have some flexibility to move rather than wait for the problem to happen and then deal with the surplus later on, because that's really putting yourself at risk.
Dr. Ang, this might be a good opportunity for you to come in and say something as well. Could we hear from you on this?
Yeah, I fully agree with Greg. When you want to raise funds, be very sure you're raising funds not only for what I call what you see in front, but when you raise funds, you must have the entire holistic picture. Because many a times when you raise funds and you just say that I want to only do this, but in actual fact, the beneficiary require a much deeper engagement so as to have the impact. And if you sit down and understand that what you want is not the activity, but the impact, and you have that scope out, then I think you will not have this problem. What I'm trying to say here is this. Please don't raise funds on impulse. Think through from point to point. So that's my first comment. My second comment is that if really, because the after you have raised funds, and that the reason for it changed, and you have gone back to go back to a lot of your donors, and some of the donors say yes. What happened to those donors that you are unable to reach because some of the fundraising campaign can be quite some time ago? It's a valid concern, you know. So when you have this concern, my question always is, did you make an effort or not? Because if you don't even make an effort to outreach to the donor and you just say, oh, because 10 years ago, therefore I assume they are not there. And when you come to me for that, then it shows that you have not made an effort. You have not exercised due diligence. And I give you another thing that you should consider. After you have exercised due diligence and you still have the funds and you want to use it, question that I always ask is, even if I cannot reach the donor finally for whatever reason, I always say, what is the intent of the donor? If you are able to assure me that the funds are always applied, not necessarily at activity level, but at intent level, write to me, and I think I have an open mind. I hope I've given you, I cannot give a definite answer because it's case by case, but at least you know what are my considerations. I am having an open mind in this. I hope that is helpful.
Thank you, Dr. Ang. That was very clear. The next question actually is directed to you as well, which is really, can the Commissioner of Charities intervene in the field of MinLaw on charities' behalf for quick justice under the COVID Temporary Measures Act? I suppose the question is whether or not COC is going to be cooperating or working with MinLaw to address potential issues which require quick determination. And because it's a charity, whether there would be some avenue for COC to collaborate with MinLaw. Would you be able to comment on that?
The answer is a definite big yes. As a Commissioner of Charities, please don't see me only as a regulator, but more importantly, also see me as a partner in building a thriving and trusted charities. I always say, you will not be alone in the journey. I will walk the journey with you. You can quote and unquote me on that, because there are many instances where I represent you to ensure that our charities flourish. So yes, please write to me in Pacific. Don't give me because when I look at the question, I don't know what injustice you're talking about. But if you have issue that I can help to make the charity, to help the charity in this difficult time, I pull out my two hands. Please write to me. You can be assured that I'm happy to help.
Thank you, Dr. Ang. Greg, you know, there are many events that are being cancelled because of COVID or deferred. And if people have been given money in advance for the event that was supposed to have been held, and then this event is now not going to take place, perhaps even within the year, What are the obligations to these donors since the event actually can't be executed? Could you tell us a little bit about your views on that?
Sure. So this goes front and center to another facet of the COVID-19 Temporary Measures Act, which is essentially the event and tourism related contracts. And this, envisages situations where events that have been held or scheduled to be held had to be cancelled because of COVID-19 related issues. So again, you can apply for relief pursuant to the legislation, serve a notification for relief, and try and see what you could do. The relief option basically, I think it's quite balanced. It's very well calibrated. What it does is that the vendor cannot automatically forfeit the deposit. The deposit will have to be treated fairly, taking into account expenses incurred by the vendor and alternative arrangements for the booking. And the client cannot be made to pay cancellation fees if provided in the contract if the event was to occur between 1st February 2020 to 19 October 2020, right? So in that sense, it provides this valuable relief. So it's balance and counterbalance because consumers can't automatically cancel contracts or get a full refund. Vendors can't set off expenses from the deposit. And where there's already been a cancellation or an agreement to forfeiture or an agreement to pay cancellation fees pre the coming into force of this legislation, then the money will not be refunded. But if you are in dispute about whether relief is going to be granted or not, then you have this avenue, and then it's going to go through assessment, and an assessor from the Ministry of Law will make a determination. And the options or the possible outcomes that may be available could include postponing the event with the vendor continuing to hold the deposit, or a partial refund of deposit to you that basically deducts expenses that the vendor had incurred, or thirdly, a termination of the contract with full or partial refund of the deposit. So those are some of the options that are available.
Thank you very much.
And I would just make a final point there that it may be your duty as a charity to explore these options so that you're actually being responsible for the donor that has been given to you.
I think we've covered a lot of ground, and as much as I would like this session to go on, I'm conscious that we're heading towards the evening now, and I think we must bring this Q&A session to a close. Just as a reminder to everyone, just remember to download the useful resources that we put up as well. And we need to sell a bit of koyok. The Law Society Pro Bono Services, right, is going to continue its efforts to serve the community by linking charitable, non-profit, and social enterprises in Singapore, which require legal assistance on corporate law matters with qualified lawyers. So, if your charity is in need of legal assistance, you can email us at, and I'll give you the email address now, assistnpos@lawsocprobono.org. That's ASSISTNPOS at lawsoc, LAWSOC, pro bono, PROBONO.org. So with that, I hope you found this webinar very useful. It remains for me to thank, from the bottom of my heart, Dr. Ang, Gregory, for your very kind and helpful and very elucidating support and assistance. I wish everyone here a good evening, to take care and stay safe. Thank you for attending our webinar tonight, and have a good evening.